Judge.
Tell me what he tested positive for.
It was THC and alcohol, Judge.
Okay.
This is where I'll add that the court added bond conditions yesterday, so he had the magistrate.
I understand.
Okay.
He did have
So-
these magistrate orders in October that I did see that he was instructed over. It didn't have no alcohol, but it did have
October what?
October
14th, 15th.
Give me the last name again.
Bledsoe, BLED.
Oh no, he's still smoking weed then. I mean, if they told him not to use any kind of illegal drugs and he tested positive right now, give me the date, please.
Oh boy, Judge Fleischer just raised the red flag. The defendant was explicitly told no illegal drugs. Simple, right? But now we've got a positive THC test. That's basically sending the judge a bolded "I don't care" text message. Real question. For you guys, should someone who violates bond this early even get another shot? Or is it straight back to jail? Drop your thoughts in the comments. I want to hear what you think.
Yeah.
This is where I will repeat my assertion that since he's out on bond, he's entitled to a hearing where the rules of evidence would apply.
What we're doing right now.
Well, then I'm going to object to hearsay to anything and everything being heard by the court.
What day was the magistrate condition for no using, please? October 20th.
I also give my spiel about THC seltzers that I could buy at Specs that have no alcohol but have THC in them.
You are not to use alcohol. You are not to use illegal drugs. I'm going to give you the benefit of the doubt, and I'm going to test you again in 2 weeks from today. If you test positive for THC again, and I don't care what it is, I don't care if it's a gummy, I don't care if it's a joint, I don't care if it's Delta 8, if it's Delta 9, if it's Delta 352, whatever it may be, you will stay with me. Do you understand?
Yes, sir.
Get whatever records you need, but if you test positive for THC again,
Yes,
you're
sir.
on notice now. You will stay with me.
Yes, sir.
Okay.
Thank you, Judge. Have a seat back in there. Come on. But did you have a preference on the reset date, Judge?
2 weeks, whatever you want.
Oh, I'm sorry. You're right. You said
And
2
I'll
weeks.
test them back and we'll see.
Do you
But
want?
by then it'll be sufficient benefit that
Yes,
there's
Judge.
just no argument.
Do you want him 2 weeks from today testing on that date?
Yeah.
Okay. We'll do. Thank you, Judge.
For sure, Nate. You are Jonathan Leatherwood.
Yes, sir.
Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Officers were dispatched to a crash in Harris County, Texas. Officers arrived and observed the defendant as the sole occupant in the driver's seat. They observed red glossy eyes, strong odor of alcohol, slurred speech, and unsteadiness. Complaining witness told officers she was sitting at a red light when the defendant rear-ended her. Complaining witness exited and walked over to defendant's car and observed an open can of beer in the cup holder. SFSTs conducted, 6 out of 6 HGN, 5 out of 8 walk and turn, 3 out of 4 one-leg stand. DICs were read and defendant consented to blood sample. His license is eligible and this is his first DWI, Judge.
And just like that boom, the hammer drops. Judge Fleischer didn't stutter. No alcohol, no weed, and absolutely no second chances. He even yanked the defendant's driving privileges right there in court. No warnings, no grace period, just consequences. Now, here's the debate: was that too harsh, or exactly what's needed to wake people up? If you think courts need to get tougher on DWI, smash that like button and let me know in the comments.
Of beer while drinking, you say? Mr. Leatherwood, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail. You will not get any more PR bonds. Do you understand?
Yes, sir.
Do you have a valid Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Yes, sir.
Okay, I'm now taking away your privilege to drive. You are not allowed to drive. Do you understand? I'm also making that a condition of your bond. I would hope that you understand it's elementary that you're not to have alcohol in the car while you are driving. Do you understand?
Yes, sir.
You have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Strauss. If he tells me he can't get a hold of you, you pick up a new case, you endanger my county, I'm going to revoke your bond. No more PR bonds for you. Do you understand? All right. I'm going to have you come up here, swear to us that you're not going to drive. I'll get you to Victoria, where we'll have you sign a reset. After that, we'll get you with Fleischer for your bond conditions, and after that, you're free to go.
Yeah, Judge, we believe, Your Honor, what was in the car was an energy drink, Judge. It was not alcohol, Your Honor.
Just what's alleged, Judge? I mean, I don't have a photo of the
Judge, he has
can,
no
but-
priors. We would ask you, Judge, to allow him to drive while on bond.
They're alleging he's got an open container of beer in the car while he's driving. I mean, you know, if you show me that it's not, I'll take it away. But I mean, they're telling me it's an open container of beer. So do this. Is the video here? Do you have anything?
Yeah, it looks like we have some body cam, Judge.
Okay, do you want to take a look real quick to see if you see something different?
Take a look. Your
No,
Honor.
I mean, we've got time. It's
Yes, sir.
9:45, you know,
Yes.
we've got
Take a
all
look. I'm
day.
ready to approach.
Well, not all day, but you know,
Sir.
take a look real quick. I'll put this on hold if you find something different, you know,
Yes,
and
sir.
once they have time, they can go out, reach to the officer, see, hey, was it really an energy drink? Was it a beer? And let's see. But if he's drinking and he's in the car and they're alleging that, no, you know, there has to,
We'll go look at it.
yeah, sure, for sure. Mr. Leatherwood, heed this warning. You won't get another one. Do you understand? Okay, come on.
All right, Davis, come on up, page 7.
What, hey, Vic, what page? 17?
7, last name Davis.
Good morning, Mr. Davis. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
The complaining witness and the defendant are married. Officers were dispatched to a residence in Harris County, Texas. They met with the complaining witness, who stated that she had called the defendant and noticed that he was intoxicated. The complaining witness then drove to the defendant's location to take his keys to make sure that he would not drive. The defendant-
Smart. Wonderful.
The defendant refused to give her the keys. The keys ended up on the ground. The complaining witness went to pick the keys up, and the defendant started grabbing her, pushing her, and hugging her as they both fell onto the ground. Complaining witness said,
All right, here's the legal twist nobody saw coming. Was it really an assault or just a drunk stumble gone wrong? The judge is clearly wrestling with intent here, and that's a big deal. Because in court, intent can be the line between a slap on the wrist and serious jail time. So Harris, what's your take? Was it a harmless fall or a sneaky move masked by the booze? Drop your thoughts below and let's break it down in the comments. I'm curious what your verdict would be.
discomfort, and the defendant was on top of her. The officer noticed the defendant was much larger than the complaining witness, leading him to believe that the defendant falling on top of her would cause pain as well.
So did he intentionally assault? Was it an accident? I don't. Read it again. You said he fell on top of her. Isn't that what you said?
Yes, Judge. He hugged her, and then they both fell to the ground. And then he had fallen on top of her when they fell to the ground.
This is a specific intent crime.
I don't think we have an offense report, Judge.
Well, nevertheless, this is what we do now. This is the probable cause hearing. You got to have it now.
This is a DVD case, Judge. I don't think that the complaining witness has been ripped yet.
Doesn't matter. We got what we got here, and I don't see intent. You know, in life, Mr. Davis, it's Davis, right? There are people who drink, they become very happy. You know, they're great to hang out with. They crack jokes. They're just the life of the party. And then there are those people, when they drink, they become the devil incarnate. They get horns. They just become terrible. If this strikes a familiar chord, don't drink. You know, it sounds like someone's trying to do something very loving, you know? Really. I'm going to find no probable cause now because I don't see intent, but just be careful. You know what I mean? Just, you got one life. Be happy and be nice. All right? Just take a seat for me, please.